Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We are responding to some inquiries and discussion relative to what exactly is the term noting date representative of in the matter styled as Steve Gonsalves et al. Versus Washington State University, which is currently proceeding in federal court, the Western District of Washington. There are currently two matters where this term has been raised. The first has to do with the motion for change of venue that was filed by the defendant, Washington State University, back on January 30th, 2026. If you look at that motion for change of venue, it's document number 8. There's a noting date there of February 27th, 2026. There has just been a second noting date in the plaintiff's motion to strike the defendant's answer. That is document number 19. It was filed on February 27th, 2026, and there's a noting date reflected there of 20th of March, 2026. What does this term signify? As we have been recommending to you, it is very important to become familiar with the procedural rules. The federal rules of civil procedure govern, in this case, and all federal civil lawsuits across the country. Those rules were promulgated by the United States Supreme Court for use in civil proceedings such as this one. But then the local courts are also free to pass their own rules procedurally to apply in civil cases, just so long as they do not conflict with the federal rules of civil procedure. Local Rule CR 7B and D deal with noting dates and noting date requirements in motions. And motions, again, are applications for a court order. According to Local Rule CR 7, the motion's noting date shall be placed in the caption. After receiving all pleadings relevant to the motion, the court will determine whether additional briefings or oral argument are necessary, or whether the matter may be decided on the pleadings. So therefore, this is pursuant to a local rule of court. And it signifies that once all of the briefings are in, motion, response, reply, then it is up to the court to make the decision whether she requires additional briefing from one or both of the parties on the two currently pending motions, or if oral argument, which is a hearing, is necessary. And in both of these motions, the plaintiffs have requested oral argument. There's another option, according to this local rule. The court may make a determination that everything that's needed, all of the argument, all of the legal authority on the papers, are enough for her to make a determination as whether the motion for transfer of venue should be granted or denied, and whether the motion to strike the defense's answer should be granted or denied based solely on the pleadings. We have provided a link to our sister YouTube channel where we've published the local rules of court as it relates to CR 7, if you would like to read it in its entirety. We will continue to keep you posted as to when the further briefings on the newly filed motion to strike answer appear on the docket, and if and when a ruling comes down on the motion to transfer venue, or the court decides additional briefings and or oral argument is required. Now that the briefings are closed on that defense motion. Until next time, this is Kathy. Thank you very much for joining us here today.